I'm Rich here at Griffin and the Griffin Law Firm. I've handled thousands of personal injury cases for my clients. I've noticed that there are 10 misconceptions that my clients often have about their personal injury car wreck accident. I'm going to go over the top 10 myths of a car wreck claim. Number 10, adjusters will always pay for your rental car until your car is fixed. This is usually the case, but there are two examples when this does not occur, and my clients are often very upset about it. First of all, if your car is totaled and the liability adjuster offers a total loss payout on your claim, then your rental car will stop. The law allows that. As unfair as that seems, the law does allow them to stop. If they're going to pay you for the replacement value of your car, they don't have to continue to pay for your rental car. The other time is if you go to a body shop of your choice and that body shop takes a lot longer than is anticipated for the repairs. Oftentimes the adjuster will say that they aren't going to pay for that excessive time in the repairs. Number 9, adjusters will always pay off your car loan if your car is totaled. Now this is one that upsets my clients the most when they are told, unfortunately, the payoff on your car is higher than the value of your car. The law only requires them to pay your fair market value of your car. Now Kelley Blue Book and Edmunds.com and Auto Trader are good sources for finding out what the fair market value of your car is. That is what they have to pay. Oftentimes people want them to pay off their car, and they do that only if the value of the car equals or exceeds the actual payoff on your car. Because cars depreciate with time and many times people have negative equity, sometimes you're stuck with the remaining balance. Number 8 on our top myths of car wreck claims. You cannot be injured if there is a low property damage or low speed impact to your car. Now adjusters, especially if you don't have an attorney, they are often going to argue that if it was a low speed or low property damage collision that you could not be injured, that there was no mechanism for injury. We do our best to explain to adjusters that that simply is not true, and the science and the studies support that serious injury or deaths can even occur when there's low property damage or low speed. Property damage is one factor, but your specific history of health, if you have a bad neck or a bad back, the way you were positioned at impact, the type of car you're driving, some cars are much safer than others, these are all factors. In fact, the state of Florida did a study in 1999 by the State of Florida Department of Highway Safety, and they did a survey of all the low-speed crashes that occurred during 1999. They found that there were 602 low-speed collisions. That means 10 miles an hour or less. In those collisions, there were 55,973 injuries. So 55,973 injuries occurred. So more often than not, people were injured even when the collision was 10 miles an hour or less. There were even 528 deaths from low-speed collisions. So that is simply not true, and that is one of the biggest arguments that an adjuster or a defense attorney is going to make. And as seasoned personal injury attorneys, we have to be able to explain to jurors why that simply is not the case. Number 7, X-rays show all injuries. Oftentimes my clients call up and they say, we don't understand, we're in such serious pain, but the X-rays done at the emergency room didn't show anything abnormal. Well, X-rays only show hard tissue. They show bones and they show dislocated joints. They don't show herniated discs. They don't show torn ligaments or muscles or other soft tissue injuries. So many times people have serious injuries like a torn rotator cuff, which even requires surgery, but the X-rays were normal. So that's often a misconception that many people have. Number 6, adjusters will always pay for all of your medical treatment. A lot of times people call me and they say, we didn't hire an attorney right away because the adjuster told us it's going to be fine, we'll pay for the medical after it's all over. Well, that simply isn't always going to happen. Adjusters are going to oftentimes say that, but at the end of the case, when they review your medical, they're going to oftentimes make the argument that your treatment was excessive or that the bills were beyond the reasonable and customary charges, and suddenly you're stuck with bills that aren't being covered. It's very difficult to get a case back on track if it hadn't been represented from the beginning. So it's very, very important to call us, the Griffin Law Firm, and let us handle your case from the beginning to make sure that we keep it on track so that you get fully compensated for all of your losses rather than at the last moment trying to get it back on track. Number 5 of our top 10 myths about a car wreck claim. Having prior personal injury claims does not have any impact on your current claim. And number 4, adjusters do not have to pay for your personal injury claim if you have pre-existing conditions. These two we're going to take together. Oftentimes adjusters, especially if you're not represented, are going to make the argument that if you've had a lot of claims before or a prior injury or health condition, that means you don't have a claim now. The law says, and we make the adjusters, and if we have to try the case, we ask the jurors to make them held responsible for the aggravation that was caused from the injury. So you do continue to have a claim even if you have a pre-existing condition or if you've had multiple claims. But those are arguments that are often made. Number 3, my premiums will go up if I use my MedPay or uninsured motorist coverage. This is a common misconception, and it is simply not true. Georgia law allows you to use your uninsured motorist or your MedPay coverage, and you can use that and should use it. You've paid to have it, and by using your MedPay, your bills get paid as you go, so you don't have to pay for those medical bills out of your settlement. You'll net more out of the proceeds of your settlement. Uninsured motorists can be very, very helpful if you have a policy limit liability claim or if you have the misfortune of being hit and injured by someone who is uninsured. The law allows you to use your coverage, your uninsured motorist coverage, to make sure that you're fully compensated. You've paid for it, you should use it, and the law says that they cannot raise your rates. But many, many times people are concerned about that and afraid to use their coverages that they paid good money for. Number 2, you cannot recover money if your injured spouse cannot have sex. Now that's a topic that people often don't realize, but there is a loss of consortium claim for your spouse. If you're married and you are not able to have physical intimacy with your spouse or just the companionship and support that one gets from their spouse around the home, then that is a separate claim called a loss of consortium claim. And the injured party, of course, has a loss of enjoyment claim and pain and suffering claim for themselves. Number 1, the biggest misconception is adjusters will pay you the full value of your case even if you do not have an attorney. This is the most important thing to realize. If you're injured, the sooner you call us, the sooner we can get started in helping you, the sooner we can tell you if you have a claim, what your rights are, what your case is worth, and we can guide you through the entire process to make sure that you get fully compensated for all of your losses. Your past and future medical expenses, your past and future lost wages, your pain and suffering, your loss of consortium if you're married, your punitive damage if there's a DUI or if there's a hit and run. These are all damages you're entitled to. And the Griffin Law Firm specializes in making sure that you are fully compensated. Give us a call at 404-303-8400 or toll free at 877-303-8440. Or use our website. We have a settlement evaluation button that you can press and type in some information that will be emailed directly to me. I will promptly let you know with a response whether you have a claim, what I think your claim is worth, and what we can do for you. Thank you.